Hello and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the country. Here are the headlines. Pregnancy outside marriage is injurious and a cause of stress, observes Supreme Court. Penal headed by former Judge Gita Mittal files report in the Manipur Violence case. Supreme Court directs CIC and State Information Commissions to ensure proper implementation of RTI Act. Rajya Sabha Chairperson refers new criminal bills to Parliamentary Standing Committee for examination. Delhi High Court hears plea challenging inclusion of CAs under the Prevention of Money Laundering Act. Advocates Kanu, Agrawal and Shailesh Madiyal appointed Additional Advocate General of Jammu and Kashmir. Now let's take a detailed look at the headlines. The Supreme Court today, while allowing a rape survivor to undergo the medical termination of pregnancy of over 27 weeks, observed that pregnancy outside marriage is injurious and a cause of stress. A bench of Justices B.V. Nagaratna and Ujjal Bhuyan took note of the medical records of the victim and said that the Gujarat High Court that did not grant her permission to terminate the pregnancy was not right in rejecting the prayer. The Apex Court permitted the appellant to terminate her pregnancy and overturned the decision of the High Court. It also said that if the fetus is found to be alive, the hospital shall give all necessary assistance, including incubation, to ensure the fetus survives. If it survives, the state shall take steps to ensure the child is adopted in accordance with the law, the top court said. The Apex Court held a special sitting to hear the matter and remarked that valuable time has been lost owing to the pendency of the matter. This order of the Apex Court is an exception to the general upper limit prescribed under the Medical Termination of Pregnancy Act, which is 24 weeks for married women, special categories including survivors of rape and other vulnerable women such as differently abled and minors. The panel of 3 retired judges headed by Justice Gita Mittal, the former Chief Justice of Jammu and Kashmir High Court, and also comprising Justices Shalini Joshi, former Judge of Bombay High Court, and Justice Asha Menon, former Judge of the Delhi High Court, has submitted its report before the Supreme Court in the Manipur Violence case. The committee was constituted by the top court earlier in August to look into the rehabilitation and other issues in cases related to the ethnic cleansing in the violence-hit state of Manipur. The court said, our efforts are to restore a sense of confidence in the rule of law while constituting the panel. Solicitor General Tushar Mehta had suggested in this regard that for the proposed committee to be constituted by the Supreme Court, let judicial officers alone be included, not the civil society groups. The Apex Court on August 1st had called the police machinery in the state tardy and lethargic in probing the incidents of ethnic violence, especially those targeting women. The panel filed 3 reports today, and the Supreme Court said the reports be given to lawyers concerned. A 3-judge bench of the Supreme Court comprising the CJI D.Y. Chandrachud and Justices P.S. Narasimha and J.B. Pardiwala directed the Central Information Commission and the State Information Commissions to ensure the proper implementation of the Right to Information Act of 2005. The CJI said that public accountability is a crucial feature that governs the relationship between duty bearers and right holders. The top court was hearing a public interest litigation that sought the effective implementation of the mandate of Section 4 of the RTI Act, dealing with the obligations of public authorities. According to Section 4, the public authorities are duty-bound to maintain records and also publish the same within a period of 120 days. Several kinds of information are included in this list. The plea highlighted the poor compliance of Section 4 while relying on reports in this regard and contended that RTI has remained an ornamental law. The Apex Court directed the Central Information Commission and the State Information Commissions to continuously monitor the implementation of Section 4, as also prescribed by the Department of Personnel and Training in its guidelines and memorandums issued from time to time. The court further said that power and accountability go hand in hand and highlighted that while all citizens of this nation have the right to information as encompassed under Section 3 of the RTI Act, the correlative duty in the form of obligation of public authorities is recognized under Section 4 of the same Act. Rajya Sabha Chairperson and the Vice President of India, Jagdeep Dhankar, referred the 3 new bills seeking to replace the British-era criminal laws to the Standing Committee on Home Affairs for examination. The 3 bills, namely the Bharatiya Nyay Sanhita of 2023, Bharatiya Nagrik Suraksha Sanhita of 2023, and the Bharatiya Sakshya Bill of 2023 were introduced in the Lok Sabha on August 11th by Union Home Minister Amit Shah. They will now be examined by the Parliamentary Standing Committee on Home Affairs, which has been directed by the Rajya Sabha Chairperson to submit its report within a period of 3 months. A division bench of the Delhi High Court, comprising the Chief Justice Satish Chandra Sharma and Justice Sanjeev Narula, today heard a petition challenging the inclusion of chartered accountants, company secretaries and cost accountants under the anti-money laundering law. The petition has been filed against the inclusion of CAs and other professionals within the definition of reporting entities under the Prevention of Money Laundering Act, wherein onerous obligations have been put on them and they can be held liable to criminal prosecution in the case of non-compliance. The writ petition challenges the validity of the notification dated 3rd May 2023 on the ground of it giving unbridled and unlimited, arbitrary and whimsical power to the authority. The plea further states that the notification is violative of Articles 14, 19, 20, 21 and 300A of the Constitution of India, as well as other civil and statutory rights, and the right of privacy and the privileged communications, which is a protection accorded to the professionals. According to the PMLA, a burden is put on reporting entities to keep and maintain records of the transactions for 5 years from the date of transaction or from the end of business relationship between a client and the reporting entity in the prescribed manner. The information to be furnished to the director with the stipulated time limit in the manner prescribed. The director can call any records from any reporting entity as per Section 12 of PMLA. Not only this, the reporting entity has to take additional measures to verify the identity of the client and examine the sources of funds of their clients and record the same. Advocates Kanu Agrawal and Shailesh Madiyal has been appointed the Additional Advocate General for the Union Territory of Jammu and Kashmir. They will be representing the UT before the Supreme Court. Mr. Agrawal is a graduate from National Law Institute University, Bhopal, and is the junior of the Solicitor General of India, Tushar Mehta. He is also an advocate on record at the Apex Court and has also worked as a legal researcher at the Supreme Court under retired Justice Abhay Manohar Sapre. Mr. Madiyal is also an advocate on record at the Supreme Court and a graduate from Bangalore University. Last year, he was appointed as an AOR to represent the UT before the top court. That was all on today's legal news. Thank you and keep watching Verdictum. And subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.